speculation.
Same.
All right, I have no more questions.
Okay. Mr. Chauvin, do you have any witnesses you were calling?
No.
And ask to bind over?
There are people who provide over charges of any argument for them.
Mr. Chauvin, any comments about bind over?
Yes. So to bind over is to go straight to court, right?
Correct.
Okay, so I do have one question though.
Hey everyone, today we're diving into a courtroom hearing that's a bit hard to follow thanks to the audio, but there's still a lot going on under the surface. This one involves a bind-over hearing, where the court is basically deciding whether there's enough probable cause to send the case up to the circuit court for trial. We'll break down what's happening, clear up the legal process, and look at how things unfold when arguments don't quite land the way people expect in court.
Very good, yeah, people.
We're here by special appearance, Your Honor, and remain in honor and not to argue but to challenge authority.
Your name?
Chauvin Robert Lewis.
Okay. This is the date and time set for a preliminary exam. Mr. Chauvin appears here on his own. As we've done in the past, Mr. Chauvin, I need to make sure you understand the rights today with regards to the potential to be represented by counsel. We've had this conversation before, correct?
I do not consent to any statutory authority presumed by this court.
Okay. We've had that conversation before about your right to have an attorney?
I am representing the all caps name, Your Honor. I am the attorney.
No, you're not allowed to do that, unless you've been issued a P number by the state of Michigan that actually authorizes you to represent someone else in a legal matter. And honestly, it feels like the more sovereign citizens are given time to speak in court, the more they keep creating these so-called special appearances that don't really exist in any real legal sense.
Okay. Do you want to have an attorney assigned to you?
No.
All right. You understand that if you wanted to, the court would have the Michigan Defense Counsel assign you.
I understand that.
Okay. You understand also the challenge of the crime you're charged with?
Yeah, I don't understand that.
The maximum penalties? It's a felony charge of non-sufficient funds check that occurred on or about May 31st, 2024. Maximum penalty is up to 2 years in prison and a $2,000 fine or 3 times the amount payable, whichever is greater. You've heard all of those maximum penalties before?
I have.
You have any questions about that?
No.
And having heard those maximum penalties, is it your request today to proceed on your own without counsel?
Yes.
Okay. You know that I have to treat you as if you had an attorney, correct?
Yes.
Okay. You know that I can't assist you in any way as we go through this hearing. You're going to have to question witnesses on your own. You make a decision on whether or not you want to testify. You understand all that.
I do have the right to question, right?
You do? Yes, you do. But I won't be able to help you with that.
Right.
You understand that? Okay. Have you ever gone through a court hearing previously where you represented yourself?
No.
Okay. Have you looked into what a preliminary exam entails and exactly how this is going to go procedurally?
You briefly explained it to me last time we were here.
Okay. Do you have any questions right now about the process?
Well, my first question is, my question really regarding the whole thing is, I don't know if she is, the prosecuting attorney is capable of even speaking.
I'm not sure exactly what you mean. My question was about a preliminary exam. I'll let you can make your motion here in a moment if that's what you didn't have, but if you have any questions about this preliminary exam?
No.
Knowing all that, all the understanding and explanation that I just gave you, your decision today to proceed on your own.
Yes. Yes.
All right. You want to bring up a couple issues?
Yes, I have an issue with the fact that under the bankruptcy of the United States of America, does the prosecutor have bonded fiduciary or sworn trust? Does she act as a prosecutor with bonding and act as a trustee for the United States? So is she able to do that?
Yes, if she is the actual district attorney, then she was elected or appointed to that role and is legally empowered to represent the state and pursue accountability in criminal matters. That position isn't symbolic. It carries real authority in court, including the ability to bring charges, present evidence, and ensure that cases are prosecuted according to the law. So when someone tries to challenge that authority without any legal basis, it doesn't really change her standing in the courtroom or the responsibilities she has been assigned.
Are you asking me a question?
Yes.
Okay, I'm not gonna answer any questions. You have a motion that you want to make. Are you challenging something? And
Yes,
say
I'd like
that the court should move in one direction or another, I'll make a decision on that.
I would like to make a motion to challenge the validity of the prosecutor being able to prosecute this thing.
Based on what? I'll give you a chance. Based on what?
Based on the bankruptcy of the United States of America.
Okay.
Because is she a trustee for the United States of America? That is my motion.
All right. Was it?
Thank you, Your Honor. Your Honor, I'm a licensed attorney in the state of Michigan. I am employed by the county of Oakland, and I have authority to exercise my prosecutorial duties within any district court within the county of Oakland. Furthermore, Your Honor, this charge is not anything that has been charged federally. Otherwise, there would be a federal prosecutor here. This is a county level from the city of Berkeley. So yes, I do have authority to move forward with these charges because the charges did come from my office, which is at the state level.
All right, and I reviewed the complaint prior to today's hearing. It complies with the Michigan court rules and the statutes that are at issue. Mr. Chauvin, you've made an objection. It's been being recorded on the record. The court's denying your objection, denying your motion. Another motion you want to make? Are we ready to go?
Yes, I also have a motion for denial of process, that this should not even be taking place because I was denied access to documents, records, by making me pay for a fee for copies, which is against the Constitution.
What copies did you have to pay for?
Copy of records.
Which records?
My court filings.
Your court filings?
Yeah, I submitted.
You needed copies of the documents that you submitted?
Yes, certified copies.
Did you get those?
I had to pay for them.
Okay.
There should be a judicial notice, I guess.
I have something here. With me. Did you get anything?
I did not hear it.
Did you want to review this?
May I approach, Your Honor?
Any response to what he's talking about?
Your Honor, I mean, with regard to getting certified copies, everybody has to pay for those, so I'm not entirely sure where the issue lies. Furthermore, they're his documents, so I'm not entirely sure why copies were needed to begin with. So and I also have nothing to do with whatever fees are issued by the court.
Sure. So those fees are, again, set by court rule and statute, your objection to the court imposing those fines, or not fines, but fees to get the copies, those are overruled. The court's just following the court rules with regards to that. Your motion is denied with regards to the impact that they have on your due process. If it did have any impact, it would be a negligible one, given the fact that they were the documents that you had submitted. And the court register of actions would just simply confirm that they were actually submitted, which you could have also done by bringing your own second copy, having a true copy made, or a stamped copy returned to you that way. But in any event, I don't believe it has any impact on the way that we're going to proceed today. So again, you made your motion. There's a record of it. I denied it, and we're going to move on to the next. So do you have any additional motions?
Yes, I have one more motion. I think that this case should be totally thrown out because there was no legitimate warrant, sir.
No legitimate what?
Warrant.
A warrant. Okay.
Which is why we're here in the first place.
No legitimate warrant.
No lawful warrant. I apologize.
Before I let you respond, what are your objections to the warrant that they would make it unlawful?
Well, I was notified of a hearing to have the warrant issued, and under law of Act 1957, I'm allowed to be at a hearing where a warrant is issued in my name.
Were you denied access to the hearing?
I've never received a notice.
Okay. All right.
Your Honor, the warrant was issued by the office, it was sworn to by the court, entered into the system. I believe that there is not only case law, but statute, Michigan law, that allows for that to occur without having the person being charged present.
I agree. I'm gonna, again, deny your motion. You made a record of it though, and that's the court's ruling. So any additional? No. All right, then everyone can have a seat, and if you want to call your, anything from you?
Yes, Your Honor, I would just ask for a mutual sequestration. I'm not sure who this individual in the court is.
Okay. Were you, who's in the court?
This is my wife.
Okay. Is she a potential witness in the case?
Your Honor, is this Kimberly Chauvin?
Yes.
She's listed on here as a witness, so I'd ask that she be sequestered as well.
Okay. Any comments about that request?
She kind of helped me with counsel though, so.
Okay. She can't do that. She's not, is she an attorney?
No.
Okay, so she can't do that, so that's not a basis for me to deny the request. So the reason that we'll have everybody step out on both sides, so that any of your witnesses except for the officer in charge would also need to be out in the hallway, is that all the testimony will then occur and no one will be able to hear it and have that influence the way that they're going to testify. So on that basis, the motion to sequester witnesses is granted. So Ms. Chauvin, you need to step out in the hallway and we'll get you when it's your turn to talk to the okay? All right. Your first witness.
Thank you, Your Honor. People call Matthew McBride.
I suppose if there are no questions left on the record, either the court might take what was said at face value and move forward as if it stands unchallenged. But that's a pretty bold approach to rely on, almost like betting everything on silence being interpreted as agreement, which doesn't usually play out the way people think it will in a courtroom.
All right, so before you get seated, please raise your right hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth. I do. Put your hand down and have a seat. Once you do get seated, if you state your first and last name and provide the spelling of both for the record, please. Sorry. Oh, jeez. Sorry. Tony's.
Sorry. Matthew McBride, MATTHEWMCBRIEN.
Go ahead and say you.
Thank you, Your Honor. Mr. McBride, where are you employed?
Credit Union 1, Berkeley.
And what is your job?
I'm a teller.
I'm going to draw your attention to May 31st of 2024. Were you working that day?
Yes.
And are you familiar with a Robert Chauvin?
Yes.
Did you see him in the courtroom here today?
Yes.
Can you please point to him and identify something he's wearing?
I guess a pale shirt.
Thank you, Your Honor. Let the record reflect that the witness has identified the defendant. I'm showing you what's been marked as People's Exhibit 1. Please take a look at that. And is that a copy of the check that was provided to you on that date?
Yes.
Did he also provide a copy of his ID?
Yes.
And once he provided copies of the check and his ID, what happened next?
So he did, I handled deposit and then he wanted to do multiple cash withdrawals.
And did you provide the withdrawals to him?
Yes.
And how were they provided to him?
In envelopes, like different denominations.
Okay.
Usually ask for certain amounts in separate envelopes, so.
And it was cash?
Yes.
So the check that was provided to you, what was the amount on that?
It was 30,000.
30,000. Okay. And how many withdrawals were made?
7.
Okay. And what were the amounts of the withdrawals?
So one for $1,024, $960, $1,500, $600, $1,200, and $2,000.
All right, Mr. Chauvin, you have the opportunity to cross-examine this witness.
I have no questions.
That's what I don't really understand is the decision here. If there was never any intention to cross-examine the witnesses or even bring forward any defense witnesses, then what was the purpose of choosing self-representation in the first place? At a minimum, an experienced attorney would have known how to challenge testimony, raise objections, or at least present some kind of structured defense that could have helped the situation.
Are people called Jillian Taylor?
Ms. Taylor, before you get seated, if you raise your hand. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes.
Ms. Taylor, where are you employed?
Credit Union 1.
And is that in the city of Berkeley?
I used to be the manager in Berkeley. I'm now at St. Clair Shores, but I was, yes.
Okay, I'm gonna draw your attention to September 5th. Did you contact, of 2024, did you contact Berkeley PD?
Yes.
Why did you do that?
Our risk management department sent over a packet to send down to them. So when they do that, they just send it to the branch manager, we call and hand that over. It was, from my understanding, it was because bad checks had been passed and was causing us a loss, so they were sending that down.
And the person who had deposited those checks, were they notified to your knowledge?
I believe so, yes.
Objection, Your Honor, as hearsay.
Did you provide a packet from your loss prevention to Berkeley PD?
Yes.
So you gathered everything up and gave it to them?
They gathered everything up, so they sent me the packet complete. I don't actually.
So you just, okay.
Yes, I just handed it over.
Okay, thank you. You're gonna,
All right, Mr. Chauvin?
you're gonna have nothing for this.
Mr. Chauvin, any questions for the detective?
Yes. I'm sorry. On the date we spoke on the phone, did you have any intent, or did you think I had any intent to defraud the bank?
Objection, Your Honor, calls for speculation.
Same.
All right, I have no more questions.
Lisa? Mr. Chauvin, do you have any witnesses you were calling today?
No.
And as find over?
There are people who provide over charges of any argument for them.
Mr. Chauvin, any comments about bind over?
Yes. So to bind over is to go to circuit court, correct?
Correct.
Okay, so I do have one question though. In my attempt to cure debt, I attempted to deposit a bill of exchange, which is lawful, and they rejected it. So why is that not taken into consideration here?
Okay, so your argument is that you tried to cure the debt, and so for those reasons, the case should not be bound over.
Yes.
Your Honor, I would just indicate for the record, you did testimony that the bill of exchange that was presented by Mr. Chauvin was indicated to be not accepted as tendered legally to the bank. Furthermore, Your Honor, that's a question of fact, not a prior effect.
All right. The court's heard the testimony from the witnesses today, the arguments of the parties. I find that the testimony provided by the two witnesses from the bank and the detective do meet the probable cause standard required at the preliminary exam to bind over this matter to the circuit court. Mr. Chauvin brought up a potential trial defense. That's an argument that you could make later on down the line. But as of today, that is a question of fact and whether or not that was an actual legal tender that you had provided. It's not a basis to deny the bind over. So that's something that we'll continue to move on down the line here. I find that the testimony met the burden. So count one is found over to circuit court for further proceedings and five to
All right. I know the audio was pretty rough and you might not have caught everything the judge said, but this was basically a bind-over hearing, a probable cause review to decide whether there's enough evidence to move the case forward to the circuit court for trial. I just wanted to clear that up so it doesn't feel like we all walked away more confused than when we started, especially after going through some of those sovereign citizen arguments. Anyway, if you liked the video, hit the like button, and if you didn't, hit dislike. Don't forget to leave a comment and subscribe with notifications turned on so you don't miss any future content.